Be ready. Ready. Start. In other non-bailable cases, the court will exercise its judicial discretion in favor of granting bail subject to subsection 3 of section 437 CRPC if it deems necessary to act under it, unless exceptional circumstances are brought to the notice of the court which may defeat proper investigation and a fair trial. The court will not decline to grant bail to a person who is not accused of an offence punishable with death or imprisonment for life. It is also clear that when an accused is brought before the court of a magistrate with the allegation against him of an offence punishable with death or imprisonment for life, he has ordinarily no option in the matter but to refuse bail, subject however to the first proviso to section 437(1) CRPC, and in a case where the magistrate entertains a reasonable belief on the materials that the accused has not been guilty of such an offence. This will however be an extraordinary occasion, since there will be some materials at the stage of initial arrest for the accusation or for strong suspicion of commission by the person of such an offence. By an amendment in 1955 in section 497 CRPC of the old code, the words "or suspected of the commission of" were for the first time introduced. These words were continued in the way new code in section 437(1) CRPC. It is difficult to conceive how, if a police officer arrests a person on a reasonable suspicion of commission of an offence punishable with death or imprisonment for life section 41 CRPC of the new code, and forwards him to a magistrate section 167(1) CRPC of the new code. The magistrate at that stage will have reasons to hold that there are no reasonable grounds for believing that he has not been guilty of such an offence. At that stage, unless the magistrate is able to act under the proviso to section 437(1) CRPC, bail appears to be out of the question. The only limited inquiry may then relate to the materials for the suspicion. The position will naturally change as investigation progress and more facts and circumstances come to light. Section 439(1) CRPC of the new code, on the other hand, confers special powers on the High Court or the Court of Session in respect of bail. Unlike under section 437(1), there is no ban imposed under section 439(1) CRPC against granting of bail by the High Court or the Court of Sessions to persons accused of an offence punishable with death or imprisonment for life. It is however legitimate to suppose that the High Court or the Court of Sessions will be approached by an accused only after he has failed before the magistrate and after the investigation has progressed, throwing light on the evidence and circumstances implicating the accused. Even so, the High Court or the Court of Sessions will have to exercise its judicial discretion in considering the question of granting of bail under section 439(1) CRPC of the new code. The overriding consideration in granting bail, to which we adverted to earlier and which are common both in the case of section 437(1) and section 439(1) CRPC of the new code, are the nature and gravity of the circumstances in which the offence is committed. Stop.